All right, class. Hello. Welcome back to LGLA 1351. This is contracts, and this week we're looking at chapter 10. This is lecture number 2 for chapter 10. And this week we are talking about performance, or specifically, we're talking about circumstances that might excuse one side's obligation to perform. All right. In the first lecture, we charged about. Well, I'm sorry. In the first half of the lecture, we talked about discharge due to unmet conditions. We talked about condition precedent, right? If the contract contains a condition precedent and one party's obligation to perform doesn't occur until this condition precedent occurs, and if the condition precedent never occurs, then their duty to perform is excused, right? We talked about discharge by agreement. We talked about several different types of discharge by agreement. We talked about rescission, right, which was just a mutual agreement by the parties to tear the contract up. We talked about modification, which is, again, a mutual agreement by the parties to change the contract or to change one or more of the obligations. Again, it has to be a mutual agreement. But if we agree to change the performance, then the old performance is excused. Now, we've got to be careful because that modification has to be a valid modification, right? And we talked about that the courts view modification as a whole new contract, right? It's a contract to modify an old contract. And so every new contract has those same requirements. You got to have agreement, you have to have consideration, mutuality, capacity, legality. But specifically with modifications, we're really worried about that consideration. A modification has to be supported by new consideration, right? If you were already entitled to something, right, that's not consideration because you were already entitled to it. So, if I offer to sell you my car for $10,000 and you pay me the $10,000 and I don't give you the car, and I say, well, let's modify that. You pay me $20,000 and then I'll give you the car. All right. Well, I'm getting $20,000. I'm getting consideration. I'm giving the car. I'm giving consideration, right? No, I was already obligated to give the car. So what's new? And if that's not supported by consideration, you can agree to it. And then when you get the car, just don't pay me the extra 10 grand. And when I try to sue you for it, you can say, no, that modification was unenforceable. It wasn't supported by independent consideration. It was a shakedown. Now, if you're trying to make a valid modification that may look exactly like that, there may be some very good reasons for that. But if you're doing that, my suggestion was always remember that new consideration on both sides. And so throw in something a little extra, right? Throw in, okay, well, for $10,000, I was going to sell you the car for $10,000. Now I'm demanding 20, but if you give me 20, I'll throw in the car and an oil change. I'll throw in the car and a car wash. I'll throw in a car and I'll throw in this highlighter, right? Now you're getting something new. You're getting the car and a highlighter. That's more than you were entitled to before. And I'm getting the first $10,000 plus a second $10,000. So now I'm getting consideration. That would be an enforceable modification. I don't mean to harp on that or make that too big a deal. That's just one of the problems that I see come up so often, especially even when lawyers are involved, where lawyers are so concentrated, and legal professionals, they're so concentrated on resolving a conflict or settling a case that they enter into some kind of modification that ends up not being enforceable, and then it just turns into extra litigation. Okay, I don't want that to happen to you. So again, our 4 types of excuse by agreement were rescission, modification. Then we had that kind of special one, that accord and satisfaction. An accord is where we agree to substitute one performance for another, and then the satisfaction is where we perform that second obligation. And when we do that, that satisfies the contract, that excuses the prior performance that was required, replaces it with a new type of performance that was required. I told you that happens. We see that a lot when there's a breach or a potential breach. These things often look like settlement agreements with lawyers, and oftentimes the exchange of new consideration. We can think of it as a modification, and the exchange of new consideration is. Yes, you had a lawsuit against me for $10,000, but you didn't actually have the $10,000. And so I've agreed to actually find the money and pay you, even though I was already obligated to pay you, right? So it can be a little hinky. So be careful with those accords and satisfactions. If you're going to enter into something that is clearly an accord and satisfaction, you want to make extra sure that everybody sees it. Maybe you title your new contract, your settlement agreement, accord and satisfaction. Maybe you state in the contract that the parties are entering into this accord and satisfaction. Or maybe you use my advice on modification and you throw in a little bit of something extra, right? In addition to this accord and satisfaction, I'm going to give you this highlighter and you're going to give me back $1, right? Now we've got extra consideration going both ways. That way we can make sure that that accord and satisfaction sticks and that some judge doesn't come in and say, you know what, I never really understood accord and satisfaction, but I do understand that modifications have to be supported by independent consideration. So belt and suspenders, right? Always better with that accord and satisfaction. And then the last one was a novation, right? Remember, novation is where that contract explodes. It's replaced by a whole new contract. And that can be important because that helps everybody understand what obligations still exist. If this is clearly a brand new contract and we're throwing out everything under the old contract, let's make sure and call our shot so that nobody thinks there's something left over from that old contract that's still hanging around, right? We want to be clear. We want to make sure, even though this is about civil litigation, even though that's how as trial lawyers make our money, we typically want to make sure that our cases do not go to litigation because it is the least efficient way to resolve our problems. All right. After discharge by agreement, we talked about discharge by operation of law. We talked about death or incapacity. If it's a personal performance, remember, death or incapacity only excuses personal performance. Also doesn't mean that the other side can't sue for their money back or something like that, but that's a remedy. We'll talk about that in the next chapter, okay? But death or incapacity would excuse a personal performance. And then, so again, if you hire me to represent you in your criminal lawsuit and then I die before your case comes up, you can't sue me. You can't sue my estate for breach of contract. Because my performance is excused due to my death or due to my incapacity. If I get Alzheimer's or I become insane or I'm in a coma, right? That would excuse that performance. Does not excuse things that the estate could follow through on, right? It's typically just business deals. Wouldn't excuse a purchase contract, right? May not excuse a lease, those kind of things. Your estate can still pay money. They just can't do the personal things that you could have done yourself. We then talked about the mother of all, the big excuse by operation of law was insolvency. We mean bankruptcy, right? And I warned you, you got to be careful. The second somebody has filed a bankruptcy, I want you to be, if you don't remember anything else about bankruptcy, remember this idea of the automatic stay. The second a debtor files a bankruptcy, there is an automatic stay, and you better not do anything else to try to collect directly from that debtor unless you're doing it through the bankruptcy court. Because if you do, you're in violation of the automatic stay. The bankruptcy judge can do all kinds of nasty things to you for violating his orders and for being in contempt of his power as a bankruptcy judge. And they're very jealous of it. Their job is to protect debtors, and they do it very seriously. That could be fining you. It could be putting you at the back of the list on priorities for getting paid. It could be putting you in jail. You don't want to go in jail. You don't want to go to jail because some guy owed you $50. That doesn't sound fair, right? So be aware of that automatic stay. As long as that bankruptcy suit is pending, you need to go through the bankruptcy court. All right. We also talked about there's other various laws like Soldiers and Sailors Act, right? If somebody gets called up to active duty, they got to go off to war. Then our law says they don't have to keep paying their rent. They can get out of their lease. Those kind of things. Then we talked about public policy, kind of a catch-all, right? If something becomes it's now a violation of public policy, then the court may excuse performance. Now, the court may allow rescission, right? May allow the other side to get their money back, but that may still, and we'll talk about remedies next week, but that may still excuse performance, okay? So, quick review of the first week. I'm sorry, the first lecture. The next category, I guess I should probably pull up the PowerPoint. The next category is impossibility. A court may excuse performance if the performance becomes impossible, all right? The court may excuse performance. It may not be a breach if performance becomes impossible, all right? Now, first of all, understand, we are talking about objective impossibility, not just I don't want to, not just it's a lot harder now. If you plead impossibility, what you mean is there is some changed circumstance that makes it actually impossible to perform on the contract. If something has come up that makes it actually impossible to perform on the contract, then performance will be excused, right? Now, this requires actual objective impossibility not just a personal opinion or a subjective impossibility. A couple of examples. If I hire you to paint my house and my house burns down, you can't paint my house, right? If you can't paint my house, then I can't very well sue you for breach because you didn't paint my house. Now, I may be able to sue for rescission to get the money back if I've already paid. But again, that's remedies. That's next week. Let me give you another example. You've got a contract to sell. Well, let me say that one. I've got a contract to sell you my car. And I'm supposed to deliver the car on Friday, but on Thursday, the car gets stolen, or it's in a wreck and it's totaled, or it gets hit by a meteor, it's just destroyed, right? Well, you probably can't sue me for breach of contract if it wasn't my fault, right? Because it's impossible. I can't deliver the car now. I may have to give you the money back, but you can't sue me for breach for not giving you the car because it's not my fault. The car doesn't exist. That's impossibility. Now, again, can't be just because you feel like it's impossible or it's way harder now. If you're going to plead impossibility, it has to be objectively impossible. All right. But there's another version, and that's commercial impracticability. Okay. Commercial impracticability. Now check on this one because it is not available in every jurisdiction. If your jurisdiction doesn't have a law on it, it doesn't have case law on it, you can still, look at the restatement, something like that. You may be able to argue for expanding law in your jurisdiction, but not every jurisdiction recognizes commercial impracticability. Texas does. Good news. So this can be a valid excuse under Texas law. And what is commercial impracticability? Commercial impracticability is where, well, maybe it's not impossible, but it's just become completely commercially unreasonable, right? It may not be impossible, but it's completely unreasonable. Now, that has to be based on unanticipated events. If it's something that was really, well, you all, the contracting parties had considered that this could happen. And so that's why maybe they bumped the price up, right? My brother lives up in Seattle, and let's say that he runs a car dealership. And so he's purchased a truckload of new Camaros, and they're supposed to be delivered up in Seattle. But this time of year, there's often a lot of forest fires up in Washington. And, sometimes you can't get over the mountain in your trucks because of the forest fires. Doesn't mean it's impossible. You can take them down to California, put them on a ship, ship them up the coast, right? So it's not impossible, but it might be commercially impracticable, right? Maybe the cost of shipping them up the coast, is triple, is 10 times the cost. And so if my brother's car lot, buys a truckload of Camaros from Chevy, and Chevy doesn't deliver them on time because of the forest fire, not impossible, but Chevy could complain that it is impractical, commercially impracticable. It's way too expensive, Judge. But in order to do that, they have to argue that this was something that was unanticipated, unexpected, right? If my brother comes back and says, no, let's look at the contract. In the contract, look how much I'm paying for delivery, right? I'm paying way more for delivery than anybody else in the United States does. And that's because we had factored in this risk that you might have to ship them by boat, right? If you could have shipped them by land, then you would have been getting a windfall because you would be getting a lot more than it cost. But if you have to, but there was a risk that you have to ship them by ship. And so this contract already takes that into consideration, Judge. Well, now that's not an unanticipated event. That's the parties contracting on who's going to take responsibility, right? Or who's going to take risk. So it has to be an unanticipated event. But if an unanticipated event occurs and it makes performance extraordinarily difficult, or so much more expensive that it would be unfair, this is an equitable remedy, that it would become unfair to force the other party to perform, then performance may be excused, right? Let me give you another example. This one actually came up. Let's say that I sell a truckload of generators to Home Depot in Houston. All right. So that's our example. We've got a contract. I sell a truckload of generators to Home Depot in Houston. Home Depot is going to pay me $500 a piece, and they're supposed to be delivered on August 1st. Except on July 30th, a huge hurricane comes through, wipes out Houston, and floods everything, right? And the interstate is 7 feet underwater. Now, Home Depot is still there. It's on a high spot. Home Depot is up on a little hill. It's on a high spot, but it's completely surrounded by water and there's no way to get to it, right? Well, at least there's no easy way to get to it. I mean, conceivably, I could get a helicopter and I could airlift each one of the generators into Home Depot, or maybe I could put them on a barge or a boat and drive them down the flooded interstate on a boat. But that's become so much more expensive that if you're not willing to go to that length, if Home Depot is not willing to pay the extra cost, then of course the seller could argue, no, maybe it's still possible, but it's commercially unreasonable, right? An unforeseen circumstance, this hurricane came in and it made it way more expensive to deliver these generators. So, Judge, please excuse my performance for commercial impracticability. Now, what are the remedies? Well, maybe the judge allows you to deliver it later. Maybe the judge allows Home Depot to get their money back. Maybe, who knows? But that's remedies. And again, that's next week. So commercial impracticability might be available in your state. It is available in Texas, but always check. Okay. Next would be frustration of purpose, right? Performance may be excused if due, again, to an unforeseen change in circumstances. It would render the contract meaningless, right, or of no further value. This is an example from a real case I had. I had a client who had hired somebody to, it wasn't paint their house, it was actually do some remodeling, but they hired somebody to do some remodeling on their house. And before the remodeling could start, their house burned down. All right. Now, they could have done the remodeling, or let's say it was painting. The house burned down on the inside. In fact, some of the roof caved in, right? But the outside walls were still there. Wasn't impossible. A painter could still show up and paint the heck out of those walls. They could be beautifully painted walls, but it really doesn't do any good, right? Because the entire inside of the house is completely burned out. There's no purpose. I mean, there's no benefit now to me having you paint the walls of a burned out house. The purpose of the contract was to benefit this house, to make the house more valuable, right? But if that purpose has been frustrated, then that may excuse performance. It may excuse me from paying you, and it may excuse you from doing the work. Okay, so it's not that it's impossible. It hasn't even become more difficult, right? You can still paint those walls for the same price. It's just that the purpose of the contract has been frustrated. So frustration of purpose can be a reason to excuse performance under this impossibility exception. Not technically impossible, but frustration of purpose. All right. Last one under impossibility is force majeure. Okay, force majeure, or a superior or overwhelming force. Force majeure, it's a French word, it's not Latin, force majeure, and it really means a force that is superior or irresistible. All right. Be very careful with force majeure clauses. People plead force majeure all the time, even when there's not a clause in the contract. And if you're going to plead force majeure, you better be careful about what things your jurisdiction recognizes as force majeure. Or does your jurisdiction even recognize force majeure if it's not in a contract? All right. The second thing you need to be aware of is if you put it in the contract, remember that a contract always controls its own terms. So if you put in a force majeure clause and you define that as certain things, then even if force majeure in your jurisdiction has been interpreted to mean even more than that, well, you modified that by your contract. And so now it may only be the things listed in your contract because you described it and defined it. So you got to be very careful with force majeure clauses. Most of the times, they're boilerplate, they're cookie cutter, right? People cut and paste them from one contract into another. That can be very dangerous because if you haven't thought it out, then there's no telling what that language is until now it's too late, right? Now the contract has already been formed, and now the parties have already agreed, and now something's happened and you're talking about suing. Now it's too late to redefine force majeure. Okay, but what is force majeure? Well, these would be things like act of God, right? Act of God, again, be careful using the term act of God because lots of jurisdictions define act of God, or your contract may specifically define act of God. And so you need to be aware of what the definition is. But But an act of God, like a tornado or a hurricane, right? You hired me, or we entered into a contract. I was going to deliver you 100,000 widgets at $1 a piece. So 100,000 widgets for $100,000, but then a tornado wiped out my factory, right? Not my fault I didn't complete the contract. It was a force majeure. Or my factory's in Ukraine and the Russians bombed it, right? That's war, force majeure. Or my factory burned down. That might be force majeure. Or it wasn't a tornado, but it was a heavy rain and my factory was flooded. Might be force majeure. The Teamsters Union went on strike, and who knew? All my workers are members of the Teamsters Union, right? So I've got now a labor strike. So I got nobody working. Might be force majeure. Or even transportation issues, right? We had a bunch of these guys during the last election driving their trucks around complaining about things, trying to start a nationwide transportation slowdown, right? Maybe that's force majeure. The point is, first of all, in a force majeure, these are always large, overwhelming, unavoidable circumstances, right? It's not, well, my one trucking company went out of business, so I could hire another trucking company. Or a couple of my workers quit, and so I just didn't hire more, right? It has to be an overwhelming thing like a hurricane or a fire or a war. Second thing you need to worry about is be careful how it's defined. Be careful how your common law in your jurisdiction defines it. Be careful how your contract defines it. Because if your contract says force majeure clause, performance is excused by acts of God, period. Well, now you're pretty limited. Now you're gonna have to look at what your jurisdiction deems to be an act of God. Your jurisdiction may deem a fire to be an act of God, but unless it was arson, right? Oh, your jurisdiction may take arson out of acts of God. Or your jurisdiction may take war or labor strikes. Maybe it doesn't consider those acts of God, or maybe it considers if there was a tornado and mass raining, that flooding is an act of God. But if you have a pipe burst and your factory floods, that's plumbing. That's not an act of God, right? So you got to be very careful and check the language of your statute. Usually not a statute, usually common law. Check the language of your common law in your jurisdiction. Check the language of your contract. But otherwise, force majeure can excuse performance, right? Again, we have a contract. Our contract has a force majeure clause that says performance will be excused. If there's an act of God or a labor shortage, and before I could deliver the widgets, hurricane wipes out my factory, you can't sue me for breach of contract because I say, hey, the reason I couldn't perform is that hurricane wiped out my factory, so my performance is excused by force majeure. Okay. So force majeure. So 4 types of impossibility excuses. Remember, they're not all. The first is impossibility, and that's actual technical, absolute impossibility. But then we have these 3 other categories. They're not exactly impossible, but they make things really harder, right? So commercial impracticability, frustration of purpose, or force majeure. All right, those are our 4 ways to excuse performance through impossibility. The next category of excuses would be a breach of contract, a prior breach, right? What if the other side breaches the contract before you do? That might excuse your performance. All right. So at common law, if one party breached the contract, then that excused the other party from having to perform at all. All right. Now let's walk through a little bit of history so I can tell you what the rule was and how it's changed. Originally, the common law required a perfect or strict performance, or strict performance. And what did that mean? It meant that you had to perform to the absolute letter of the contract. And if you deviated from it at all, then you hadn't strictly performed, or you hadn't rendered perfect performance. And as a result, the other side's performance was excused. All right. So if we have a contract, you ordered a brand new yellow Camaro online, and it was supposed to be here on Friday by 4 o'clock. And you show up Friday at 4 o'clock, and they're still taking it off the truck. I can't put it in your hand Friday at 4 o'clock. You could say, aha, not perfect performance, not strict performance. I can walk away. Bye. Right. Or let's say I'm a grain elevator, and you had I'd contracted to sell you 100 tons of wheat, And so you pull up, railroad car after railroad car, barge after barge, and we fill them and we fill them and we fill them. And it's not 100,000 tons. It's 99,999 tons, and it's a couple of ounces short, right? Does that mean now you don't have to pay at all? Because I didn't render perfect performance. I didn't strictly perform. Well, under the common law, any deviation was not strict performance, and any deviation by the other side would then excuse your performance. Okay. Now, as you can see from those examples, that was pretty harsh. And so most courts, most jurisdictions under these principles of equity have softened that strict performance or perfect performance doctrine. And now most courts would require substantial performance, meaning that you have to require substantial performance has any number of different definitions in any number of different courts. But basically it means that you had to meet the main purpose of the contract, right? As long as you have complied with the contract in such a way that you've rendered most of the benefit to the other side, they can still use it, right? Then you have substantially performed. So if you contract to sell a car at 4 o'clock and you don't get it to until 4:15, well, you're 15 minutes late, right? The contract has still met its essential purpose. You've still gotten a car. That was the purpose of the contract. If I'm going to sell you 100,000 tons of wheat and I've only got 99,999, well, we've substantially performed, right? You've gotten most of the benefit of this contract. And so the court's not going to view substantial performance. Substantial performance is still a breach, but it is not the type of breach that would excuse your performance then, right? Like in those two circumstances, your required performance would be to pay. So if I'm a minute late delivering the car, or the car was missing one extra little detail, right? You wanted a USB charger and it had a cigarette lighter, that one little difference, then you could claim a failure of strict performance and say, well, I'm not paying. But a court now would likely say, well, no, that's substantial performance. So yes, you still have to pay. Now, is there a remedy? Sure. Again, we'll talk about that next week, but the remedy would generally be that you could sue for whatever damages came from the shortfall, right? Like if I was supposed to deliver 1,000 tons of grain and I only delivered 999, then you still have to pay, but you don't have to pay for that last ton that you didn't get, right? You may even get some credit for any expenses that you had to incur getting that extra ton if you needed to. But again, we'll talk about remedies next week. Along with substantial performance, the flip side of that coin is material breach, right? So only a material breach will excuse performance by the other side. What is a material breach? Well, a material breach is the opposite of substantial performance, right? So if I'm supposed to deliver 1,000 tons of grain and I only deliver 999, then that's substantial performance. That missing 1 ton is probably not a material breach. But what if I'm supposed to deliver 1,000 tons of wheat and I only deliver 50, right? Well, that's a material breach. Maybe you don't want 50. Maybe 50 doesn't do you any good. That's a material breach because that 50, when I'm supposed to be delivering 1,000, is not substantial performance. That material breach would excuse your performance. Again, remember that's a chapter we're talking about, performance or circumstances that would excuse performance. So we don't require perfect or strict performance anymore. We require substantial performance, but a material breach will still excuse the other side from performing, okay? Last thing to talk about when we're talking about prior breach is a time is of the essence clause. What is a time is of the essence clause? Well, time is of the essence clause is very simple. You may see them, you've probably seen them in a contract somewhere before already. Time is of the essence clause sometimes says just that. Sometimes that's all it says. Time is of the essence, period, right? Sometimes that section will have a heading and a separate paragraph number, and the parties hereby agree that time is of the essence. Don't have to go that far even. If you just put in the contract, time is of the essence, you now have a time is of the essence clause. And what does that mean? It means that the parties in their initial contracting have agreed that time, that any deviation in time is a material breach, okay? Is a material breach. So any deviation in time is a material breach. Therefore, if somebody's 15 minutes late, 15 seconds late, The parties have already agreed that that 15 seconds is a material breach because they put in the contract, time is of the essence. And you will see that in contracts all the time. Sometimes it's very, very important, right? I put those in settlement agreements all the time. If the party's supposed to pay us, I don't want to be jacking around with, well, they paid late, or, well, they, and so we put time is of the essence clause, right? And I usually make it, the settlement payment is due at 3 o'clock on Friday afternoon, even where the payment is due at my offices at 3 o'clock on Friday afternoon. Why? Because if they're not there at 3 o'clock, I still got 2 hours to get the lawsuit filed, okay? Or I still have 2 hours to file the motion to reinstate, whatever. So a time is of the essence clause is a special clause that you can put in a contract, even if it just says time is of the essence. And what that is saying is that the parties have agreed ahead of time that any breach in the time element is a material breach, even if it's 1 minute, okay? So that is the common law on a prior breach. Now, I was going to say we haven't talked about our good friend the UCC, but we did. We just talked about Article 9 or Chapter 9 in Texas of the UCC just last week when we were talking about third-party transactions, right? Security interests. Well, the UCC treats prior breaches a little bit different. The UCC has its own rules, okay? And it is worth reviewing and going back and remembering what our purpose of the UCC was, right? Remember, the purpose of the UCC was to facilitate trade, to make things go smoother so that merchants could engage in business more and worry about their lawyers less, all right? And so the UCC has its own rules. The first rule in the UCC is the perfect tender rule, right? And we talked about perfect performance or strict performance. And the UCC's perfect performance rule says that a buyer, that if a buyer doesn't make perfect tender, okay, then as long as the deadline on the contract hasn't expired, then the buyer has a reasonable time to either accept or reject the goods for that failure, okay? They have a reasonable time to review the goods and to either accept or reject them, all right? But if they don't reject them, then they will be deemed to be acceptable, all right? Now, how is that different from the common law? Well, the common law, if you rendered performance, even if the deadline hadn't passed yet, you rendered performance and you were 1 pound short, well, you had tendered performance and it wasn't perfect, so now you're in breach. You tried to perform, you screwed up, so you're in breach. Under the UCC's perfect tender rule, if you perform, then if it's not up to snuff, if it's not a perfect tender, then the buyer has a reasonable time to reject the goods. And if they don't, the failure is waived. Why? Well, consider what that does. If the buyer delivers something and it's not good enough, then if the seller tells them, maybe the buyer has time to make it right? And we would call that cure. We would call that a cure. We'll talk about that in 2 seconds here. Does that really happen? Sure, it does. And sometimes it happens for very good reasons, right? Remember, we're talking business people. I use my grocery store as an example all the time. Let's say that I have a contract to buy a truckload of oranges from, I own a grocery store, and I've got a contract to buy a truckload of oranges from my produce wholesaler. And my produce wholesaler is supposed to deliver them on Friday by 3 o'clock in the afternoon. And Friday morning, he shows up and drops off a whole truckload of tangerines, right? And I see this, I'm like, what the heck? I don't like tangerines. None of my customers like tangerines. I don't want these stinking tangerines. This isn't perfect tender, right? He didn't tender perfect performance. He didn't tender exactly what he was supposed to. So I call him up and I'm like, my dude, these are not oranges. These are tangerines. And maybe my seller says, oh yeah, I know. I don't have enough oranges to meet all my contracts this week. But tangerines are more expensive and you're one of my favorite clients. So I thought I would give you more than I was obligated. I thought I'd give you tangerines instead of oranges, hoping that you could sell those instead. You'd make even more money and you'd be happy. But if you're not, I'll come pick those tangerines up and give them to somebody else, and I'll give you the oranges, right? That kind of thing happens all the time. That would be a breach under common law, but under the UCC, the seller has the ability to make that effort to try to comply with the contract in a different or even better way. and not take the risk of it being a breach. And that way, if the seller doesn't like it, I'm sorry, the buyer doesn't like it, then the buyer can reject the goods and say, no, 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 I'm not taking these tangerines. I want my oranges, as long as they do so in a reasonable time. If they don't reject within a reasonable time, the UCC says, well, you had your chance. You must have accepted these, right? You don't get to take the tangerines, try to sell them, and then if you can't sell them, then sue the seller, right? Then sue your supplier, because that's unfair. Right? We want to facilitate transactions, but we want to do it in a fair way. So that's the perfect tender rule under the UCC. A seller who does not make perfect tender, the buyer has a reasonable time to reject the goods, and if they don't, then the failure is waived. All right. Now, the UCC also defines trade usage, right? What are the customs in the industry on whether or not some flaw or some perceived defect is acceptable? All right. Like I may have a contract with you to sell you 3-inch widgets, and the widgets all show up, and there's not a single one of them that's 3 inches. Some of them are 2.9, some of them are 3.1. There's not a single widget in the batch that is 3 inches long. Is that a perfect tender? Well, the contract says 3 inches. So is that perfect tender? Well, if in the trade, if in our industry, a 1% deviation is acceptable, well, then they're all within that 1%, right? So even though they don't look like they meet the language of the contract, if they meet the trade usage, then that would be acceptable, right? Or if I ordered a truckload of oranges, but it just says oranges, right? What kind of oranges? Are they navel oranges or blood oranges, or what kind of oranges are they? Well, I don't know. What does oranges mean in trade usage? Or if we just say oranges, what types of fruit are acceptable to meet that orange, right? That may be governed by trade usage. Doesn't necessarily mean it, but trade usage would mean customs in the industry as a whole, okay? That's a little bit different from course of dealings. Course of dealings may also affect what is acceptable or unacceptable, but whereas trade usage is what is acceptable industry-wide in this industry that you and I are both parts of, course of dealing is just what has been acceptable just between me and you, right? Maybe the whole rest of the world would say, no, a tangerine is not an orange. And so if the contract is for oranges and you deliver tangerines, that's a breach, right? But with me and you, we've been doing business for 20 years. And, a couple of times a year, you've delivered tangerines instead of oranges, and I've always accepted them, right? So industry-wide, trade usage may not be acceptable. But our course of dealings, just between me and you, it has been acceptable. And so maybe our course of dealings has modified what is perfect tender, okay? So that would be course of dealings versus trade usage. Trade usage, big picture, course of dealings, just between me and you. But that can affect what the actual language of the contract says when we're trying to determine whether something was perfect tender or not, all right? And then again, that leads us to this idea of cure that I already mentioned briefly. If within a reasonable time, the seller notifies the buyer, the buyer notifies the seller that they are rejecting the goods, then if there is still time left on the contract, then the seller has a chance to cure by delivering the conforming goods before the contract deadline, okay? So if our contract calls for those oranges to be delivered at 3 o'clock in the afternoon and you deliver them at 10 a.m., and at 11 a.m. I call you and go, these aren't acceptable. Well, if you can deliver the right stuff by 3 p.m., then you can cure, right? And there's no breach of the contract. Whereas if the contract requires you to deliver at 3 o'clock and you deliver at 2:30, you may have shot yourself in the foot. You may not have a chance to cure anymore because you're just too close to the contract deadline, right? What is a reasonable time for me to review and reject these goods? Is it 30 minutes? Maybe it's only 5 minutes, but even if it's only 5 minutes, if I reject them in 5 minutes, do you have time to get a new truck over there in the remaining 25 minutes? Okay. But that is cure. So cure is if a buyer rejects goods under the UCC, rejects non-conforming goods or a non-conforming performance, then the seller may still cure by tendering conforming goods within the time, within the deadline of the contract. Okay, so that would be a cure. All right. All right, last category, and then I think we're almost done. The last category we're going to talk about of things that may excuse performance is called an anticipatory breach. Okay, an anticipatory breach. And it is definitely similar to the breach that we just talked about, the prior breach, right? If the other side breaches first, then that excuses your performance. That's a prior breach. What if they haven't breached yet because maybe their performance isn't due yet? But we just think that they're going to breach, or maybe they've even said they're going to breach, right? They say they're going to breach, but their time for performance hasn't occurred yet, right? What if I order that new Camaro and I'm supposed to deliver a check on Thursday and they're going to deliver the car on Friday? But on Wednesday, I hear that they're not getting those Camaros in on Friday. Well, do I want to go give them a check on Thursday? They haven't breached yet. But what if I don't bring the check Thursday and then they sue me for breach, right? I'll be in breach of the contract because I was due to pay them on Thursday and I didn't. And then they sue me for breach when they weren't going to be able to deliver the car on Friday anyway. Well, an anticipatory breach may excuse future conduct, okay? Let's talk about the different types of anticipatory breach, okay? Anticipatory breach, the first type would be repudiation. When one party makes a clear statement by words or actions, doesn't have to be words, it can be by actions, but if one party makes a statement by words or actions which clearly indicate that they will not perform, right, then that may rise to the level of an anticipatory breach. Let's say that the car dealership calls you and they say, hey, these cars aren't going to be here on Friday, but they'll be here Monday. Well, that's an anticipatory breach. They're telling you ahead of time that they're going to breach the contract. So what do you do on Thursday? On Thursday, do you pay anyway? Or do you rely on that and say, well, if they sue me, I'm going to be able to claim that there was an anticipatory breach? Well, you might need to talk to a lawyer, right? Because that's going to be a fact question, that anticipatory breach. What evidence do you have? And what exactly did they say? Did that rise to the level of an anticipatory breach? But if it does, and they try to sue you later because you didn't pay on Thursday, you can always argue to the court, well, they repudiated the contract. They told me they weren't going to be able to perform. And so I hired somebody else. I'll give you another example. I had a friend who hired a babysitter weeks ahead of time, hired a babysitter, a girl they always use. And the day before, they had her scheduled for weeks, and the day before, she said she wasn't going to be able to make it because she had some lame excuse. And really what it came down to is she just didn't feel like it. Well, they were going to a wedding. They had this planned days before, weeks and weeks and weeks before. They freaked out. And they told her how disappointed they were, but what could they do? They're not going to sue a babysitter. And so they raced around. They managed to hook up another babysitter at the last minute. They had another babysitter come. The new babysitter knocked on the door, and she was there. And 5 minutes after the new babysitter showed up, what happened? The old babysitter knocked on the door, said she was there to babysit. And they said, sorry, we don't need you. You told us you weren't going to make it, and so we hired a new babysitter. Now, could the old babysitter say, hey, we had a contract. I'm supposed to be here. So whether you want me to babysit or not, you owe me because we had a contract. No, those parents could probably argue, well, you repudiated, right? You had an anticipatory breach. I know you didn't breach until Friday because Friday was the day you were supposed to show up, but you repudiated it. And so it was reasonable for us to rely on that. But they'd have to prove the repudiation. It'd be their burden of proof. So they want to make sure they have some kind of evidence. All right. Next category would be just what we would call an anticipatory breach. An anticipatory breach is when by one party's words or actions, it can be viewed as a breach, right? But by their words or actions, they haven't said they're not going to perform on the contract, but through their words or actions, they've made it clear that they're not going to be able to perform on the contract, all right? And if you can prove an anticipatory breach, that may be a valid excuse to not perform, right? So again, let's go back to my grain elevator, right? I'm supposed to buy 1,000 tons of grain from the grain elevator. And I'm supposed to pay them on Thursday and pick up on Friday. But on Wednesday, I hear that they just got a big fat contract from a bunch of European countries because they're out of grain. And they sold all of their grain to European countries, to Eastern European countries, and it's gone. And now the grain silo is empty. So do I have to show up on Thursday and give them my money just to wait for them to breach on Friday? No. Through their actions, they've made it clear that they're not going to perform, right? Maybe they didn't even tell me about it. but it is now impossible for them to perform. So that's an anticipatory breach. Okay. And that would excuse me paying them on Thursday because they've anticipatorily breached ahead of time. Now, that can be tricky too. How do I know that they're not going to be able to meet my contract? I hear they sold out all their grain. The silos are empty. Maybe I can sneak over there. I look at, and their silos are absolutely empty. And I'm like, man, I'm not paying them on Thursday. They're not going to be able to come through on Friday. And so I don't pay. And then they sue me and they say, yeah, but we had some other trucks coming in. We were going to be able to serve you too, but you didn't pay us. So we're suing you for breach. You'd have to be careful, right? You need to talk to your lawyer. You need to look at what evidence you have and what the likelihood of them being able to carry through on the contract is. All right. So here's the thing about that. Under common law, an anticipatory breach must be clear. Okay. It can't be based on just assumptions. It can't be based on feelings. It can't be based on doubts. It has to be clear. And that can be tricky under common law. But let's talk about our old friend, the UCC again. Okay. The UCC recognizes that that is not a real efficient way for business people to do business. And so the UCC has a whole separate mechanism for anticipatory breach. Okay. A couple of terms to understand when it comes to anticipatory breach and the UCC. The first term is an insecure party, insecure, not unsecure, not UN, an insecure party. An unsecured party, we talked about last week, right? An unsecured party is somebody who's loaned money but doesn't have a security interest, right? A secured party has a security interest. So your bank has a lien on your house if you take out a mortgage. That's a secured party. But if you just borrow money from your father-in-law to buy a house and he doesn't take out a lien, then he's an unsecured, an unsecured party. An insecured with an an insecured party is a term of art. It's a specifically defined term under the UCC. And an insecure party means a party who has a good faith reason to believe that the other side is unlikely to perform. Okay. A party who has a good faith reason to believe that the other party is unlikely to perform. Now, under the common law, if you're feeling uneasy about the other side performing, you just got to decide whether you're going to perform or not, and then take your chances, right? And then take your chances if they're going to sue you for breach or not, and take your chances that your claims of anticipatory breach are going to be valid. Under the UCC, that insecured party has another mechanism. The insecured party can send a communication and demand assurance, okay? And assurance is the next defined term under the UCC. An assurance is a pledge or a guarantee of performance, okay? A pledge or a guarantee of performance. Now, the UCC doesn't go into a whole lot more detail, but it's a pledge or a guarantee of performance that is reasonable, that makes the buyer reasonably confident that either the seller is going to perform or that they're going to have some kind of method of redress, right? So under the common law, if that grain elevator sells out all their grain and you don't think they're going to be able to meet your contract, then you got to take your chances on whether to pay on Thursday if you're delivering on Friday. Under the UCC, since now the UCC would apply, we're talking about the sale of goods, right? We're both merchants. So the UCC applies. I could say, you know what? I'm feeling insecure and I don't think you're going to be able to follow through on this contract. I'm not 100% certain, but I don't think you are. So I'm going to send you a demand for assurance. Now you've got to give me assurance or else my obligation to perform is excused. What could that assurance be? Well, could it be just an email back saying, oh no, man, we got you. That's probably not good enough, right? But maybe you could show me the contracts, show me the bill of lading for the other stuff that's coming in. Or maybe you could give me a lien against the stuff that's coming in tomorrow. Or maybe you could give me a letter of credit from your bank saying that if I pay you the money, they're going to hold on to it so that I can get it back on Friday if you don't perform, right? Those kinds of things would be assurance. And if you don't give me assurance, then under the UCC, if I have a reasonable basis to believe that you're not likely to perform, if I demand assurance and then you don't give it, then that is an excuse to performance, that I do not have to perform. And that's what this chapter is about, okay? A couple more concepts and then we'll be done. One is mitigation. With an anticipatory breach, or even with any breach, mitigation is, it's actually an equitable defense, okay? The plaintiff is required to try to mitigate their damages if possible. What is mitigation? Mitigation is an effort by the innocent party to limit or reduce their damages caused by the other side's breach, okay? So if there is a way that you can minimize your damages, then generally you have an obligation to do that, okay, if it's reasonable. If it's reasonable. Now, again, this probably belongs to Chapter 12 under remedies, but let's talk about mitigation. So, for example, a friend of mine, a good friend of mine, owns a flower shop, right? And let's say that he's got this big wedding coming up, and they're going to pay him $50,000 for this wedding, and they want white roses. Man, they want white roses everywhere. And so my friend has a contract with the with a wholesaler to deliver a whole truckload of white roses for this wedding because he's going to use them on that $50,000 contract. And let's say that the wholesaler calls and says, hey, you know what? They just didn't come in, or we sold them to somebody else, or whatever their excuse is. We're not going to be able to deliver those white roses. You'd ordered 1,000 roses at $1 a stem. You were going to pay us $1,000, but we just don't have the roses. We're not going to deliver. Can my friend just throw up his hands and then sue them for the $50,000 he's going to lose because they didn't deliver the 1,000 roses? Well, that's one thing he could do. But what if he could just go next door to the other wholesaler and buy white roses there? If he could just buy white roses from another wholesaler and still meet his contract, then it's not fair to let him just let that entire contract go and rack up the damages against the first guy, right? Now, what if those roses cost a little bit more? What if they cost $1.25 instead of $1? Well, he has a duty to mitigate his damages. That's reasonable, right? He'll pay a little more for the roses. That way he can still meet his $50,000 contract. He still makes that huge profit, and then he can sue for the damages. Then he can sue for that extra 25 cents a stem, right? So if there's a reasonable way where you could limit your damages, right? You've got a contract for me to buy widgets, and I don't deliver them, but you can get those widgets from somebody else to build your machines or your computers or whatever. Then you have an obligation to do that if you can do it reasonably. Okay, if you can do it reasonably. Now, if it's too late and now white stem roses are $50 a stem, that's the only way you can buy them because you're buying them one at a time from every 7-Eleven in town. That's not going to be reasonable. You're not required to do it. But generally, the duty to mitigate means if there's something that you could do reasonably to limit your damages, then you have a duty to do that. Okay, it's actually an affirmative defense. The defendant would have to plead it and prove it. But if they can prove that you failed to mitigate your damages, that may limit your remedies. Okay, and that leads us to a concept under the UCC. Last concept also under the UCC, and then we'll be done. And that's the concept of cover. Okay, cover, one more defined term under the UCC. Cover is a buyer's right, their absolute right to obtain replacement goods if the other party breaches or if the other party is anticipatorily breached. Okay. They have a right to cover, to buy replacement goods, and then sue the seller for the difference in price. Okay, again, probably belongs in Chapter 12, but it's here, so we'll talk about it in Chapter 11. I'm sorry, but the right to cover kind of goes along with that duty to mitigate, right? The right to cover. If somebody breaches or there's an anticipatory breach, then you have a right to go out and buy replacement goods at a higher cost and then sue the defendant for the differences, right? The difference in the higher cost and any extra expenses, maybe that required extra transportation, extra handling, that kind of stuff. You can sue for those damages too. That would be the right to cover. Now, what if you buy replacement goods at a lower price? Do you have a right to do that? Sure, you have a right to cover. Can you still sue the defendant? You can. But what are your damages? You're doing better now, right? So in that situation, you have a right to cover. Your performance, you don't have to pay the first guy because he didn't deliver the right stuff. But you can cover, you buy from a second guy, and then you don't sue the first guy because you came out better anyway, right? That would be cover, okay? That's the chapter on performance, or specifically on the circumstances that would excuse performance. If you have any questions, give me a call, shoot me an email, let me know. Otherwise, you got a couple of assignments this week, so get those done, and I will see you next week. Thanks. Bye.